going in depth into these aspects of commercial transactions and commercial viability of the contracts and everything. So I assume that most of your law schools would have already dealt with contracts, not the contract drafting part, but the essentials of contract, basics of contract. What is a contract? Offer, acceptance, offeree, consideration. So so in this particular camp, we won't be going in depth into what is a contract, because that is already covered. That part is already clear. So if one of you, just for the sake of the whole team, if one of you could unmute and just say what is a contract and the essentials of a normal contract, that will be very helpful. Anyone can do that. Anyone can raise your hands. Anyone of the students can raise their hands if you are comfortable. Okay, fine. That's okay. So you all know what is a contract. Contract is essentially a legal document between two people, where the essentials of contracts includes there should be an offerer, an offeree. An offerer is someone who is offering. An offeree is someone who's accepting. And then there should be a consideration, a legal valid consideration, which could be a monetary benefit or could be any other things, as well as the legal consideration, and there also should be acceptance by both the parties. These are the essentials of a valid contract. Now let's go into commercial contract drafting. Now, when you say commercial contract drafting, it is nothing but the contract that we use in a commercial transaction. Now, what is a commercial transaction? A commercial transaction is transaction between two companies or two entities where there is a considerable, or the consideration is the amount, which is a very big amount that we use, that we transact. Could we go to the next slide?
Yes, sir.
Also, guys, please feel free to stop me at any time. Raise your hands. You can stop me, and then we'll have questions. We'll also have a question round session at the end of the session as well. So before that, if you have any doubts, you can please feel free to either put it on the chat or you can raise your hands if you want to address the team. Okay. Now, what is commercial drafting? It is the art and science of preparing legal documents that is used in a commercial transactions. So, like I said, what is a commercial transaction is already understood. Now, what are these legal documents? These legal documents could be, there are multiple legal documents that we use in a commercial transaction. They are SLAs. SLAs are service line agreements. Essentially, service line agreements are agreements that is for a service. Now, suppose if I am, let's say I am a carpenter and I get into okay, let's forget that. Suppose I am a professor and I get into a service line agreement with Legal Lock saying that I will provide my services of a professor and Legal Lock will pay me this much amount for my services as a professor. Now that is a service line agreement. Then we have NDAs. NDAs are non-disclosure agreements. NDAs are signed between two entities before a contract is set. Now NDAs are precursors to a valid contract. They are signed before a contract is set so that important things can be discussed between the two parties. Suppose NDAs are normally used in science field, mechanical field, innovation fields, where before we get into a viable contract, we want to discuss details or innovative ideas that we are set for. But if we just go and tell our ideas to a company, they might misuse it. So we get into an NDA which prohibits them from disclosing certain aspects of it. NDAs are also signed by employees of various corporate organizations. In future, if you join a corporate organization, you would be required to sign the NDA, which prohibits you from disclosing any trade secrets of a company. Then you have contracts and agreements. Can any one of you tell me the difference between contract and agreement? Come on, guys, I would prefer a very interactive class rather than me just coming and saying random lines and then saying that am I going. So if anyone, one of you could just give me a very basic idea of what is a contract and what is an agreement. What are the difference between two? It would be very helpful. Any one of you.
A contract is an agreement with legal backing.
Okay. A contract is an agreement with a legal backing. Then what is an agreement?
Uh, it's a consensus addendum between two parties.
Okay, that's a great idea. So is all contracts an agreement or is all agreements a contract?
So all contracts are agreement, but not all agreements are contract.
Good. Exactly the point. And what is, and can some of you point me what is the key word in it? Why is all contracts an agreement but not all agreements are a contract? What is the key there? Why is it like that? There's one word.
Enforceable by law.
Exactly. All contracts are all contracts are agreements because they are enforceable by law. Perfect. Good answer. See, when we are doing this interactive session, it's more nice. Exactly. Now, when we go into commercial drafting, there are certain things that we require, which is every commercial contracts have to be precise, to the point, very clear, and they also needs to have legal enforceability. Now, what do you mean by legal enforceability? Legal enforceability essentially means that if the contract is broken or if the contract has any issues, the law will be providing or the law will help you to sort it out. That is legal enforceability. Anyone can just get into a contract, but yeah, if it does not have a legal enforceability, then there's no point in having the contract. So legal recourse or legal help that you can get is called legal enforceability. So in India, you cannot get into any contracts which are unfavorable or which are illegal. Now, what are illegal contracts? Contracts which goes against the uh, which is where the consideration is something illegal like arms, bombs, weapons. These contracts. I'm talking about contracts between two people. Okay, I'm not talking about defense contracts. Now, don't come and say that we have defense contracts. That is completely different topic. That is a commercial contract. We'll discuss that later. Okay, perfect. Anyone has any doubts till now? Yeah, I saw someone unmuting. Then Shri I saw unmuting.
No, sir. It's clear.
Okay, perfect. Just a thumbs up on the reaction would be nice if you guys are clear. Perfect. Vaidehi, can we have the next slide? Importance in corporate and transaction law. Now, why do we have these contracts in these? Why do two entities, two big corporations? So now I work for Deloitte, and my main, I work for Deloitte and I work in the government sector. So my main client is the US government. Now, why does the US government and Deloitte need to have contracts? Why do we need to have contracts? Why can't we just shake our hands on something and be like, okay, great, let's go? Why do we need to have contracts? Someone has any thoughts on that? Why do we need contracts? Anyone? Okay. All right. So now why do we have contracts? We have contracts because we need to be very clear on what do we have, what are our rights, what are our duties, and also to minimize disputes. Now, if there is no contract, it is our word against their word. So essentially, there could be a lot of conflicts. We never know that in the long run where there could be a situation where conflicts could arise. We never know how the situation or the relationship falls apart. We never know all of these aspects. So there are a lot of ambiguity there, which is not good for business. When there is ambiguity, it could always backfire for a business. So that is why we always prefer to have ironclad contracts. Now, what are ironclad contracts? Ironclad contracts are contracts where we ensure that no contract can be 100% successful or no contract can be 100% strong. So we, as a contract negotiator and drafter, we make sure that to the best of our abilities within the legal framework, we can make it as strong as possible. That is ironclad contracts. Now, in every contracts, we define the rights, the duties, and remedies of party. These three are very important. We need to know what is the offerer offering. We need to know what is the offeree going to do. We also need to know what if there is a fall down or if there is a fallout, what are the remedies for these parties could be. Most of the cases in commercial contracts, could you guess what is the remedies for parties? I don't want a section. I don't want all of that. Just give me something that you guys could, or top of your head, what do you think could be the remedy for a party in a commercial contract?
Negotiation.
Could negotiations we do before the contract is signed? This is a remedy. Like if it falls apart, what could be? If when a contract falls apart, what could be the remedies?
Restitution.
Restitution is nice, but yeah, restitution is nice. That's a good answer. Anything else? Anyone? Come on, guys. Okay, fine. Remedies. The majority of commercial contracts prefer arbitration. Now, why arbitration? Because no companies do not want to go to court cases. We try to minimize court cases because of financial reasons. Let's be honest. Indian legal laws as well as any other country laws, it takes a lot of time for companies to get their cases go through courts. It is time consuming, money consuming. So most of the companies, 99% of the companies, we prefer to have the contracts or any disputes remedied through arbitration or mediation. So we will have an arbitration clause in 90% of the contracts. No, make it 99% of the contracts will have an arbitration clause. And once arbitration falls, only we'll go to in extreme cases. Only we'll go to court cases. Now, this is something that I want all of you to keep in your mind. A contract is only as strong as its weakest clause. You can have, so I'll give you a live example. This was a contract that Deloitte got into USAID. I don't know if you guys know about USAID. USAID is an organization in US government which gives money to various other countries, like poor countries, example, like Somalia and African countries, where they fund these countries for humanitarian aid. So Deloitte had a contract with USA. It was like each commercial contract will be hundreds of pages. The biggest contract that I saw was 1,232 pages. So in these contracts, there were one small payment clause which said that if there is a delay of the deliverable not being given, then the payment could be delayed for 90 days. So the analyst or someone who worked on it at that time, they did not notice this. So this was a very weak link, and it passed. And this was a 10-year contract. For 7 years, there was no issue happening. In the 8th year, there was a deliverable delay, and we did not get paid for 90 days. So this was a very weak link that could have been avoided if it was negotiated properly. So I want you guys to know that a contract is only as strong as its weakest link or weakest clause. It's a very important thing. Keep that in your mind. Any questions till now? Any questions? If not, a thumbs up will be nice. Then we can go forward. Perfect. Thank you. Thank you. Vaidehi, can we have the next slide? Yeah. Types of commercial contract. Types of commercial agreements. Like I said, we have sale and purchase agreements. Sale and purchase agreements are agreements between two companies or two corporate entities where we are selling and purchasing an agreement. Sorry, selling and purchasing a particular goods. We have NDs, like I explained before. NDAs are non-disclosure agreements, where which prohibits one party from disclosing what they see, what they hear, what they work on. These are the three pillars of an NDA. Then we have employment and consultancy contracts. Now, employment contracts are your offer letters. In future, once you pass out your law school, you will join various corporates, law firms, multiple other options. These are employment contracts where they will specify your job title, your salary package, and the benefits, and what all you're supposed to do, what all you're not supposed to do. Consultancy contracts are contracts where an independent third party is hired by a corporate to do consulting for them for a particular project. Any doubts till now? Consultants, you know what is consultant, consultancies, employments, NDAs, and sale and purchase. Any doubt?
So do we have NDA clause in India? So,
Yes. So NDAs in India is a very, how do I put it? NDAs in India is a very tricky thing right now. So there are judgments in favor as well as in opposing NDAs in India. Right now, in the current scenario, we do have NDAs in India. NDAs are there, but again, they are for legal reasons only. We cannot have an NDA which prohibits a company from which prohibits someone from disclosing an illegal item. You get my point?
yes, sir.
Now, guess what could be? So that's what. So if it is enforceable in India, it is perfectly enforceable. It's just that you cannot have an NDA which prohibits, which what you say, which covers up a illegal item or an illegal way, which again illegal something that we did, and which again goes back to the enforceability or goes back to the basics of contract, where any contract cannot be considered valid if it involves an illegal substance. Got it?
Yes, sir. And also, would you repeat the three pillars you said
For
about
an NDA. Yeah. For three pillars of NDAs will be what you see, what you hear, what you work. So essentially, you cannot tell what you see, you cannot hear what you see, you cannot say what you hear, you cannot tell what you work on. These are what NDAs usually work. Then you have joint venture agreements. Can anyone guess what is a joint venture agreement? Any guesses? Any wild guesses? I'm not looking for exact answer here from you guys, but any wild guesses?
Is it like a partnership?
Um, good thing. It is not. It could be a partnership. It's not exactly a partnership. So joint venture agreements are essentially where two or more parties, two or more different companies come together to collaborate on a specific project or a business activity. Or it creates like it talks it, or it could be to create a different company as well. Now, these joint venture agreements are mostly seen in defense sectors as well as big pharma sectors, where for a specific uh, period of time, two big corporate entities, they come together, pool in their resources to create that particular thing. Now, during COVID-19, India opened the bids for creating vaccines. So we had Covaxin, I forgot, we had Covaxin and Covishield. These are the vaccines that India provided. So these vaccines were created by multiple companies. They got into a joint venture agreement. We had Pfizer joining with biotech Serum Institute. So Pfizer and Serum Institute came together, got into a joint venture agreement to build this vaccine. Similarly, we have this happens all the time. Now, in these venture agreements, they will clearly specify what is provided by company A, what is provided by company B, and also what is the profit sharing. These are some of the main things that you see in a joint venture agreement. Then we have licensing and franchisee agreements. Licensing and franchisee agreements are agreements which essentially gives someone a license to use someone else's product. So licensing agreements are usually seen in, you can see licensing agreements in the film industry, musical industries, these industries where you are licensed to use the product. And franchisee agreements are between big corporate and small companies where they get to use the corporate name, or the corporate use the big corporate's name and product to sell their product, to sell it in this to be sold by these small companies. And for that they get a profit sharing, which is usually some 30-70, 60-40 split. Could anyone give me an example of a franchisee agreement? Any franchisee that you know in India. India has lots of franchisee. Any franchisee that you know in India?
Natural size cream.
McDonald's.
McDonald's, natural size cream. Good. These are good idea. These are good.
Starbucks.
Sorry?
Starbucks.
Starbucks is not a franchise. Yeah, Starbucks has franchise system, but they are not. Most of the Starbucks are directly owned by Tata Group directly. Very few. But McDonald's, KFC, natural size creams also good. That are also good option. But the biggest franchise in India right now is KFC and McDonald's. We also have Domino's. Then we also have sorry. Then we also have Chicken as another very big franchise in India. Then we have service level agreements. Like I said, these agreements are for services that we render from one party to another party. Cool? Any doubts? Thumbs up if you don't have any doubt. Yeah, perfect. Can we go to the next slide, please? Good. Now, these are the key principles of a commercial drafting. First will be clarity and precision. No vague language. Can anyone guess why do we emphasize on clarity and precision? We emphasize on clarity and precision because there could be an ideal contract should be a contract which has zero place for error, or which has no place where they say that, okay, fine, there is where there is a scope for a loophole. So if a contract is as clear or as precise as it could be, we leave out scope for loopholes or ambiguity. So this is why we focus on clarity and precision. Now, consistency is very important. So you cannot create a contract where you say something on the first page and you contradict the same line in the 5th page. So suppose you say that this contract will be enforced. This contract, the place of performance for this contract is Madhya Pradesh. And then in the 8th page, you say that Hyderabad is considered to be the primary place of performance for this contract. So there's a contradiction, which is inconsistent, and therefore that contract will be rendered invalid if there's an inconsistency. So we need to be consistent, and we need to define all the properties in a particular order without. We should be very sure about what we are saying, and there cannot be any contradicting on what we write itself. Now there should be structure. Now a contract needs to have a particular structure. In starting, we have the opening page. In tomorrow's class, I will show you a proper contract where I'll show you what are all the terms, agreements, and everything. So do not worry about how the structure will be. I'll show you the structure of a contract. Now, a contract will start with the opening slot, or we have the opening clause, which mentions about the two parties involved. Then we'll have the definitions, which essentially talks about the key words and their definitions that we will be using in these contracts. It is not compulsory to have a definition page. definition pages are there for contracts which goes on for a very long period, which has multiple key scientific terms that is not understandable for most people. But definitions are not very important. But if it requires the contract, then we will have definitions clause. Then we'll have multiple other important clauses like place of performance, period of performance, NDA clause, arbitration clause, then deliverable clause. Now, what is a deliverable? A deliverable is something that is given, that is the fruit of the contract essentially. What you get out of the contract is a deliverable. Now, legal lock and I got into a contract to take this class. This class is the deliverable from that contract, or it is the fruit of that contract. So that is a deliverables. So there will be deliverable list and also a deliverable schedule. Essentially, that says so and so year mein so and so of things will be delivered. So in the contract between me and legal law, the deliverables are 3 hours. Oh, sorry, 4 hours of classes. Where 21st we will have the first session of class, and 22nd we'll have the second session of class. These are the deliverables that is involved, and this is the deliverable schedule. So that is one of the main clauses. And then a very important thing that cannot be missed out from a commercial contract are signatures. Signatures field are very important. You won't believe how many times I have come across contracts where the parties forget to sign. When a party forgets to sign, that contract is rendered invalid because there's no point in having that contract if the parties have not signed. Understood? Any doubts? No doubts? You know what to do if you don't have any doubts. Perfect. Then we have risk allocation. Now, what is risk allocation? Risk allocation is anticipating the liabilities. Anticipating liabilities may what could be the anyone can guess what are the liabilities that could be there or that could arise out of a contract. Any guesses? Wild guesses. I'm not looking for exact answers.
Or default in payment.
Default in payment is a liability. Then we have breach of trust is a liability. Breach of contract is a liability. Act of God is a liability. Then we have places where the contract has gone beyond the scope of the initial contract. These are all liabilities. So there's a section where we'll list down the liabilities as much as we can. Now, no contract is 100% we can foresee the future, but we'll list down there's a standard set that is followed in the industry. It is industry specified. So IT field has a standard sets of liabilities that they follow. Manufacturing sector has a standard set. So each sector has a standard set that they follow, and we try to fill it as much as possible. Then we have enforceability. Like I said many times, it talks about the legal binding and the practical things that could follow. Legal binding will say that there has to be a valid consideration, a valid acceptance. It should not be a contract for anything illegal stuff like that. Then customization. Now, every contract has to be made for that particular situation only. There are templates, but each template has to be tailored fit for that particular purpose because each contract, each situation is different. So you cannot, it is very frowned upon to reuse the old contracts again and again, because if that is the case, then there's a high chance that we might miss out on something important or something new that has been added. So it is always suggested for you guys to to take templates. You can there will be templates. All major corporations, major companies follow templates, and from the template you have to build it for this particular agreement or for a particular purpose. Any doubts? Any doubts?
Where are these templates given or provided somewhere?
So in corporates, if you join any corporate, each corporate company has their own templates. So they follow their own template that has been created. Similarly, So there is no hard and fast rule that you have to follow the template or anything. A template is just something that is created to help you guys out. So I will send you guys some templates for NDAs and all these. But most of them are, so essentially a template are the ones where, like I said, the structure, the basic structure of the contract. These templates will have those basic structure, and from there we build it upon it. So you cannot reuse the contract is what is the essence of it actually.
So it means the basic elements remain the same, and
Yes.
other elements are customizable.
Exactly. The basic elements will be same. The basic clauses will be same, but then from one contract to the other, the additional clauses will keep on changing. Okay, perfect. Can we move on to the next slide? Yeah. See, this is an anatomy of a well-drafted contract. Essentially, these are the basic things that needs to be have there. There's a visual sample that I'm supposed to add. Because I thought I'll show you the contract tomorrow, so that will be easy for you. Now, a contract will have title and introduction. It will have definitions, obligations of both party A, party B. Payment terms is essentially what we are getting. Termination is how the contract is terminated. And then the governing law is the governing law under which this contract will fall under. We also will, now these are just the basic components of a contract. So most of the contract will also have liability clause, like I told you. Then we'll have arbitration clause. Some contracts in the IT sector will have NDA clause within, like there will be a separate NDA agreement. At the same time, they will also have a non-disclosure clause in the commercial contract. So that will also be added. Any doubts here? Okay, perfect. Can we move on to the next one? Next slide. Yeah. So these are some of the sample clauses that I deal with regularly on commercial contracts. Sorry for the page alignment. So confidentiality clause is a sample clause. This is the wordings that we usually use. You can see the receiving party shall keep all confidential information strictly confidential and shall not disclose it to any third party without the prior written consent of the disclosing party. Then we have the governing law clause, which will be something along the like this agreement shall be governed by and construed in accordance with the laws of so and so place. Usually in India, it will be Indian laws. US may US laws. In US, it will be state laws. Then we have termination clause. Either party may terminate this agreement with 30 days prior written notice. So that is a termination clause. So like these the language that we use. I wanted to show you guys the language that we use in agreements. So I just copy pasted some examples of some clauses so that it will be helpful for you guys. Any doubts here? Perfect. Can we move on to the next slide? Okay. I want all of you to take a screenshot of this page. Just take a screenshot of this page. If all of you took a screenshot, just give me a thumbs up. Yeah, perfect. This is your exercise for tomorrow. We will discuss this tomorrow. You guys have to draft an NDA for a company sharing sensitive data with a freelance. Sensitive data could be anything, that is up to you guys. You know what a freelancer is. A freelancer is someone who works for multiple companies together. They are not in employment with any one particular company. Right now, I am a freelancer working with Legal Lock for this class. Similarly, Legal Lock as a company will be having multiple freelancers taking multiple classes for multiple people. So that is what a freelancer is. Now, in your class, in your NDA that you're drafting, I don't want ChatGPT NDAs. I do not want all these online NDAs. I don't want a very 20-page NDA where they're doing a lot of stuff and everything. I just want four simple sections in your NDA, which is purpose of disclosure, your confidentiality, your duration of confidentiality, and your governing law. That's it. So these just make a document with these four aspects. Cool. Any doubts? Okay, thank you, Dhanashree. Anyone else has any doubts? Perfect. Any move on to next slide? This is some of the tips for effective commercial drafting. Use clear and unambiguous language. Make it very simple. Avoid legalese unless necessary. Most contracts, please keep it simple. You do not need to have you do not need to put Latin words and all. This is not a statute. This is a commercial contract is not a statute. A commercial contract is not a legal judgment where you need to use unnecessary Latin words and Latin proverbs and all these legal maxims which normal piece of people won't understand. So you do not need to use Shakespearean languages. You do not need to use uh, all these complicated words. Make it very simple. Make it very easy for someone to understand. Now, like I said, definitions. You need to define all key terms in the beginning itself. You need to be precise about your obligations and remedies. These are very important. Obligations, because what you write under obligations are what the parties will do. If you write in obligations that party A will give you 10 mangoes every day, then party A will give you exactly 10 mangoes only. Even though if you wanted 12 mangoes also, the party A will only give you 10 mangoes. They'll be very precise on that. So you have to be 100% sure on what the obligations has to be. Similarly for remedies, if you write that you will go for arbitration, then you will have to go for arbitration. You cannot break and go for court cases. If you say you want to go for mediation, then we have this mediations. So that it has to be very there. And a contract, commercial contract has to have a commercial contract has to be perfect in formatting and numbering. We cannot go crazy. We cannot go wrong in that. It has to follow the same font size, same font, same page numbering, everything. You cannot make it into a mess where the first page will have font size 10 times New Roman. Third page will have Calibri body with font size 80. So it cannot be like that. It needs to look clean. Then you also always have to keep in mind your jurisdictional nuances. Now, can anyone guess what is a jurisdictional nuances? Anyone? Guys, anyone?
So if there is an arbitration clause, we need to be keep in mind that what will be the seat and venue or something like that.
Yeah, that could be that is a good answer. Jurisdictional nuances also includes where your jurisdiction of your contract is going to be. So if you say that in India, it is not very much different. In India, jurisdictional nuances are not very great because you also have the option to go to Supreme Court. But it is also considered because, see, ease of business, when you do something in the court, the High Court directions for certain things. So the High Court of the High Court of Bombay has given out certain judgments, which is helpful for film industry to work. But those same judgments have only persuasive value when it goes to the next High Court. So if you are in, say, Madhya Pradesh and you are doing something which could be very much easy in Mumbai, but it is not that easy in Madhya Pradesh. So these jurisdictional differences, territorial differences are what comes under jurisdictional nuances. I put this because I mainly focuses on US, and in US Each state has their own laws. There is no federal Supreme Court system. Each state has their own laws, and one state's laws do not apply to the next state. So that is why jurisdictional nuances are very important in other countries. In India, we do not have a lot of headache on this. So I just wanted to put it out there so that you people can think on it. Any other doubts? Any doubts you guys have on this particular topic? Yes, thank you. Can we move on to the next slide? Yeah. Now, these are some of the common mistakes that I want you guys to avoid when you're commercial drafting. Omitting definitions for key terms. Like I said, if the contract is vague, then you cannot give. So what happens when there is no definition? So if there is no definition, then it is open to interpretation of both parties. And my interpretation could be different from the other party, and he or she's interpretation could be different from mine. So that will leave for a conflict of interpretations, which would eventually lead to a fallout of the contract. So that is why we put out key term definitions all the time. Then using inconsistent terminology across clauses. Somewhere you use the word, somewhere where you use the word place of performance, some other places you use you say place where the contract is happening instead of the terminology being properly used. So these inconsistencies will cause again a place for people to interpret their own versions of it. Then we are failing to specify jurisdiction or dispute resolution mechanism. Like I said, under which state will the jurisdiction be, or what will be the dispute resolution mechanism, like arbitration, mediation, court cases, which seat of arbitration would be taken. This could also cause an issue. So then we have overloading a clause with multiple obligations. Now, overloading a clause with multiple obligations is something that you need to keep in very mind. You cannot have a clause which runs for 10 pages because people lose to 10 tracks of it. That way, you are supposed to break down your clauses into subclauses so that people can understand a better way. And suppose let's take example, let's take NDA. You cannot disclose something that you see while working in our company. That is a very simple clause. If you break this clause, you need to pay so and so amount. Two subclauses, understood, perfect. But then you overload this clause, overload this clause by adding more concept to it. Like you will add something like you will add some clause. You can add a subclause which says that you cannot disclose anything that you see here, but you are allowed to disclose what you see in some other room, or you're allowed to disclose what you see after your working hours. So these kind of overloading or making it complicating with multiple obligations create a problem for us to understand the contract and for as well as for to enforce it. Then, like I said, the last one, copy pasting. Copy pasting is considered to be very ridiculous when you go to contract drafting, because like I said, each contract has their own particular way of handling it. So this, any questions anyone has on this? I am open to questions now. We have 10 minutes. I'm open to questions. If you guys have any questions, if you guys have any doubts, something you want to do, something you don't want to do, any examples you want to ask. Anything? Okay, let me see if I can pull out the contract right now. 1 second. Just give me 1 second. I'm just searching for a contract. Okay. Yeah. Um, am I allowed to share my screen?
Yes, sir. Just a minute.
Okay.
You can share it now.
Is my screen visible?
Yes, sir.
Perfect. Now, this is a personal privacy notice that Deloitte has. So Deloitte sends out this contract or this contract to everyone who joins their company. This is essentially a contract that we give out to collect permission to collect private information about an employee. So here you can say there is an introduction clause. This introduction clause specifies what this is. This is a privacy notice applies to personnel of each of the Deloitte US firms. Then they talk about the uh, like I said, the definitions. These are the definition. What is Deloitte US firm? Deloitte US firms mean Deloitte LLP. We, us, and our refers to Deloitte US firms. Personal means an individual that was in or became employed. Deloitte Network refers to Deloitte Touche member firms. So this is the definition clauses that we were discussing earlier. You understood? Then we go on to what is the obligations. Now, when you go to obligation, we can see this is what Deloitte is going to do. They're collecting the following personal identifier information: your name, contact, date of birth, government ID, financial account number, your financial information about your family, dependents, and other informations. They also collect your race, ethnicity, medical, religion, criminal records, trade union, sex life or sexual orientation, political opinions. They also take information regarding your. So this is how your information is being collected, is what Deloitte is saying. And then we have information to collect about directly provides to us, information we may receive from other firms, information we may receive from third parties. Then there is also about compensations and benefits. They'll talk about your performance. So they will also talk about your. They will also then they talk about where they are disclosing this information. This information they share with other entities to fulfill their obligations. See here, this is a very important part where they say that we do not sell or lease your private information to anyone. So here, then we have the next clause which talks about consent. See, we will not obtain your consent to processing. Then your relationship with us changes. So this is essentially your former person. So once you leave the country, sorry, once we leave the company, they can still use your personal information for their use. Then you have access clause, information security clause, your notice, your change, and your questions. So, and your clauses. So this is where I signed. This is my signatory part. So this is how a contract, this is how a very simple information contract will look like. Any questions? Do you have any questions from anyone? Anyone has any questions? I'll go in depth about these contracts tomorrow. I'll show you an example. I have a template for an NDA and everything, which I'll show you tomorrow. But apart from that, any other questions from anyone? By the way, I think we can wrap up for the day if no one has any questions.
Okay, everyone. Thank you so much, sir, for having such a great session with us and sharing your contacts and everything. We shall continue tomorrow then.
Yeah, perfect. Thank you, everyone.
Thank you, sir. Thank you, everyone, for joining.
So I can leave the meeting, right?
Yes, sir.